All right. Good evening, ladies and gentlemen. We're going to do our cumulative course review this evening, so that way we can kind of go over, kind of brush over every subject matter we talked about, and kind of what we learned, just to refresh you um, for the semester. Let me put my phones on vibrate. Okay, make sure we're not interrupted. So, of course, this is our courtroom testimony. This was our textbook. And that is winning court testimony for law enforcement officers, the law, art, and science of effective court communication by Matthew Medina, and this is the only edition. Um, Relatively thin textbook here, pretty much a how-to book, kind of just about effective court communication. Because this class is essentially about preparing you guys for the possibility of being called to testify. So, of course, whether you're going to be in a position, law enforcement, maybe a medical examiner or some type of expert, you have to expect to be called in court. But even if you're not going to have a job where you expect to be called in court, if you want to be a lawyer or something like that, you at least need to know the rules of evidence and certain things that apply. It's still, I think a lot of this stuff applies generally to most jobs in the criminal justice sector. So, started out chapter was section 1, which was called the basics. Chapter 1, we pretty much just talked about the anatomy of a jury trial. So, you need to know how a jury trial goes, what it's made up of. So, outside of like the pre-trial stuff, the motions and stuff like that, once the trial starts, and that's where you're going to be called. You're going to be most important as a witness during trial. Very little of what they need from you as a witness is going to be needed pre-trial. Sometimes there's certain motions, or there may be some type of questioning, some type of pre-trial motions where you may be called to testify, but for the most part, it's going to be during the trial. The anatomy of a trial, we talked about the jury selection, of course, being important. Once we get from there, then we have opening statements from both parties, beginning with the prosecution, then the defense. Then we have the prosecution's case in chief. Of course, they have the burden of proving guilt and the burden of production of evidence, so they have to go first. Then from there, if the defendant chooses, before we even get to what the defendant chooses, there's the right of cross-examination. That means every witness that comes up is subject to cross-examination by matter of right for the other side. So, the major thing we learn is that physical evidence does not get in without being testified to. And we learn that also that testimony is evidence. So, matter of fact, not only is it evidence, it's the only way physical evidence gets in. So, what a person says in a courtroom on the witness stand is evidence. And matter of fact, it's more than what they say. It's how they dress, how they present themselves. All that stuff becomes evidence because what they're saying is important and it's evidence. But the onlooker and the trier of fact, they're taking the source of the evidence and what it's wrapped up in. So you as a person, your reputation, how you dress, whether or not you seem like you care about what's going on, all that stuff matters. And that's essentially what this class is about, making sure that you can testify and come to court and be effective, be believable, know what you're talking about, and be effective, because that's the only way to be an effective witness. If we don't believe you, then you're not very effective. So then from there, back to the anatomy of a trial. Then there's cross-examination of all witnesses. Then from there, you have the defense case in chief, where they get the chance, if they choose. Now, remember, the defense does not have to put on evidence, but if they choose, they get their case in chief, in which all their witnesses are subject to cross-examination, just like the other side. Then at the close of all evidence, once both sides are done, then you have the closing arguments. And it depends. So the closing arguments are important. It's pretty much an oration of what happened, a summation. and they get to be pretty argumentative because all the evidence has been there. They get to kind of give their qualitative point of view of all the evidence, and they're trying to persuade the jury to see it their way. Find the defendant guilty, or if it's the defense, find my client not guilty. So they're trying to be persuasive. They're trying to use points of evidence and things that the jury has already perceived, and they're trying to persuade them to see it a certain way. So those are that's what we call the closing argument. And then from there you have jury instruction and jury deliberation, and then there's a verdict. So that's pretty much all the steps of a jury trial. We talked about prosecution witnesses. It's all about communication, how to prepare for court. The fact that if you're a prosecution witness, and this goes for any witness, whether it's prosecution or not, you're being called to be a witness by a party in the case, either the prosecution or defense. It's incumbent upon that attorney that's calling you to have talked to you, to interview you, to know what you're going to say, to know what's going on, and to kind of prepare you for trial, because you're their witness. They're calling you to be there. You'd hope they would have had a debriefing of some sort to let you know the purpose and why you're there, and what they're trying, and what they're looking for, what they're trying to get out of you. In other words, they're trying to say, what did you see? That right there, that what you just told me, that is important. So then when we move to chapter 3, we'll talk about what to do before court. Just your preparation. Of course, if you're in law enforcement, or if you're in some serving in some capacity, even as an expert, you need to prepare before court. Prepare meaning that you don't have to memorize everything, but you might want to read over your notes and remember what you said. You don't want to get caught up saying something that's inconsistent with notes or narrative that you've already published, because then it looks like something's a lie. Either you're lying today or you were lying that night. So you never want to be inconsistent. So sometimes the most important thing to do is to refresh your own recollection before trial. If you know you're getting called in a certain case, you want to be, review your notes and know what happened. So you got to think, police officers encounter hundreds of people in a day, and no telling how many arrests or how many times they charge people in a day. So you're coming to court to testify now as a law enforcement officer in this one case out of probably 50 cases that you encountered just in one day. And you're being called, maybe it doesn't even get to trial till 6 to 8 months, sometimes a year or more later. And it's like you've encountered so many new cases since that day. So it's nothing wrong with having to refresh your recollection, looking over your notes. So preparation is not about memorization. It's about just reviewing your notes, knowing what you said, and being able to go to them in certain situations. With the permission of the court or the judge, law enforcement officers can actually use their notes to refresh their recollection if need be. So just prepare for court. That's what it's about. Know what you're talking about. If you are an expert witness, and you've done some type of scientific research that's relevant to the case, then make sure you know what you're talking about. Review what you did. Know why you came to that conclusion. So that's what that's about. Then we moved on to chapter 4 and 5, persuasion and courtroom demeanor. As I said before, how you look, how you dress, how you act is very important, because you as a witness, you are walking, talking evidence. What you say is important, but the package is coming from is also important. So your demeanor, how you dress, all that, I hate to say it, all that stuff matters. Eyewitness testimony, we talked about the fact that eyewitness testimony can sometimes be the weakest testimony, unless it's, and it's the weakest because a lot of times, especially if we have encountered a traumatic event, right? Something that happened to us, a gun was in our face, we got shot at, something crazy happened. You got to think, when it happened, it was traumatic when it happened. So your brain's already everywhere, and you don't necessarily remember everything. Sometimes whether or not what you were moving when it happened, were you in the car, you witnessed it, was a car driving by and you saw something, or so there's a lot of stuff. Was something in the way? So eyewitness testimony is sometimes the most unreliable testimony, because you have memory that comes into play. Like I said, perception. Did you see what you thought you did? so the human brain is frail. So once again, we're asking you to come back and tell us something you saw. Um, and sometimes whatever you saw happened very quickly anyway. But you're now having to come back more than a year later to remember and tell us exactly what you saw a year and a half ago or something like that. So eyewitness testimony is sometimes the shakiest testimony, especially when it comes to identifying someone and saying that person did it. Especially sometimes when it's cross racial, so we see that a lot. So as an eyewitness to a case, your perception is definitely going to be challenged. So that's definitely going to be challenged. What was in your way? What was going on? Had you been drinking? Something like had you been using drugs, or was there anything that was affecting your ability to remember or see or perceive it? So you're going to be questioned. You're going to be put to the fire. Um, in that situation. So eyewitness testimony is sometimes because of that some of the weakest testimony that comes into court. Um, then it ends with chapter 7, just a few rules for the road. From there, we moved on to section 2 of the textbook, where we talked about direct examination and the rules that apply to direct examination. Direct examination is just the form of questioning. So direct examination means you are getting called as a witness, and you're being questioned by the side that's calling you. If you're the cop if you're a police officer and you're being called by the prosecutor, and they get to question you first, then that is what we call direct examination questioning. Um, it's the type of questioning you should be ready for, because hopefully you've been debriefed and you've been prepared before trial to know, okay, we're gonna ask this, so you won't come in there blindsided. You should never be blindsided doing direct examination. The attorney that's questioning you is the attorney you know, and the attorney that asked you to be there in the first place. Um, so that's direct examination. Of course, there's certain rules. You cannot ask leading questions. So you must ask direct questions. So what is a leading question? And we'll talk about later on as well. But a leading question is a question that suggests the answer in the question itself. So if I say, isn't it true? I mean, if I say, Mr. Johnson, were you on the campus of A&T the night of April 15th, 2020? That's a direct yes or no answer, right? I'm not suggesting the answer. I'm asking the person simply where they were. And I'm not pushing them into an answer within the verbiage of the question itself. Now, that is the direct question. Now, what is the leading? Now, how can I ask that same question but ask it in a leading form? If I say, Mr. Johnson, isn't it true that you were on the campus of North Carolina A&T on the night of April 15th, 2020? Now, that isn't it true? I'm pushing them into the question. Or if I say, you were on the campus of A&T, weren't you, Mr. Johnson? That is what we call a leading question. That is not allowed on direct examination. The only exception to that rule of only direct questions and no leading questions is when they're called when you classify a witness that you're calling, and this is from the attorney standpoint, as a hostile witness. Sometimes you're calling the witness to prove your case, but that witness doesn't want to help you, or they're there against their will, and they don't want to be helpful. So you know that this person is going to automatically be hostile towards your questions. In that situation, of course, usually you got to give it a couple questions to see how the person acts. Then if this person is not cooperative or they're non-responsive to your questions, as an attorney, you can ask the judge for permission to treat the witness as a hostile witness. Once they're classified as a hostile witness, now you can add the attorney that called you is allowed to now ask a leading question. So that's the exception. That's what we call the hostile witness exception, and the court has to give you that permission to treat him as a hostile witness before you can just go at asking them leading questions. So we talked about in direct examination, precision and simplicity. Use simple language, be precise, know what you're talking about. Talked about language, jargon, and tone. In other words, don't use cop speak or slang. Your volume being able to be heard, right? Chapter 10, we talked about phrase and word pitfalls. Never use phrases that either disqualify what you've already said or qualify what you're going to say. So stuff like if you've been if you've been on the stand for 10 minutes and been asking questions, then you're answering the question. You say, well, to tell the truth, once you say, well, to tell the truth, what that means is a high probability that everything you said before you said to tell the truth was a lie. So you're essentially saying I was lying before, but now to tell the truth, going forward, this is what happened. So you want to stay away from that. You want to stay away from stuff like probably. If you don't know, let them know you don't know for sure. If you're not 100% certain, make sure that's known and questioning. What you don't want to do is look like a liar or someone that doesn't know what they're talking about. That's why the stuff you do know, you need to let them know I know that, but that I do not know, because you don't want to be be fumbling and bumbling, and you don't want to because once you get caught up and you kind of get caught up acting as if you know something, but then we find out you don't know as much about something, or you're not very knowledgeable, then that breaks down everything you've said before, even if you are an expert on everything you said before. So if you just come out and say, hey, I can't talk about that, didn't see that, don't know what happened, but I do know about this, that solidifies your testimony. So that's chapter 10. That was and that was the end of section 2. Section 3, and the final section of the textbook. Well, before we even get there, we jumped out of the textbook for a few classes, and we talked about the Melendez-Diaz and the Crawford v. Washington case. Those are what we call our hearsay cases. What is hearsay? It is an out-of-court statement made by a person that's not present in court, and that statement is being offered to prove the truth of what the statement is saying. So what that means is there's a person that said something to someone else, and that person that said that is not available in court, but the person who they said it to is. Now the person who they said it to is now coming into court, and they're trying to repeat what was said to them. The problem with that, and the reason it's so unfair, and the reason it's generally not allowed unless there's some type of exception, and usually the exceptions for that rule are based on the reliability because of the situation in which it was said, the statement was given, but it's generally not allowed, and it's inadmissible in court because the opposing party does not have the ability to cross-examine the statement of someone that's not there. So if you're able to get this statement in, but the person that made the statement is not there to be challenged or questioned, and they're not there to at least explain the situation, it's unfair to the other party, and it kind of goes awry of the Sixth Amendment confrontation clause, and that's the right to cross-examination witnesses against you, or to cross-examine witnesses against you. So if there's essentially a witness's statement being allowed to come in, and you can't do any, and the opposing party can't do anything about it. The person's not there; they can't challenge them. So if it comes in and it's okay, it is what it is. Then what is the other side? How's the other side going to challenge it? Generally not allowed. So like I said, it's two prongs to the hearsay test. It's that out of court statement made by someone that's not there. It's been offered. And that person that actually said it is not there. Then 2, it must be offered to prove the truth of exactly what they were saying. So if the statement is Boyce killed Mr. Johnson, I saw Brenton Boyce kill Mr. Johnson, but that witness isn't there, but the person they told is there to say what they said, then if it's being offered into evidence, that statement is being offered to prove that I killed Mr. Johnson, then it's inadmissible. Now, if it's being offered for some other reason, let's say if it's a different trial, if it's a trial to determine whether or not I'm dead, or what my time of death was, or let's say even the time of death of the person that said the statement, then that means they're not offering it to prove that I killed somebody, but they were offering it to prove that I was alive, or they're offering it to prove that the person that saw me kill someone was alive when they said what they said. So in that situation, it's not being offered to prove the truth of what the person said about what they saw me do. It's being offered for another purpose. So it's not just about it being an out of court statement, but you also have to examine why it's being offered. What is the purpose for the questioning? And sometimes you have to figure out the purpose for the questioning by listening at trial, and this is for my future attorneys, and knowing the context for which it's being offered. Where are we at in trial? What are we talking about? Why is this important now? So you have to ask those questions. So that's what we talked about in specifically the Crawford case. The Melendez case was more about a statement, not necessarily a verbal statement, but a written statement by an examiner, by a lab technician that tested something, and they were able to just send a piece of paper to court to say, hey, that was positive for cocaine. It is what it is. So what happens is that piece of paper that says this is cocaine via, we did the test and our report says it's cocaine. That statement in itself is just dropped in court and no one's there to testify to it. So that statement itself is also hearsay, and it's not allowed. So the issue is the opposing counsel can't cross-examine a statement. So what that means is the person or the body or the scientist or whoever did the report and created that report that drew a conclusion. They have to be there. They can be questioned and cross-examined as to what their methods for testing was and everything. So there's another form of hearsay. Hearsay is just not someone coming in to say, well, she said this. It can also be in the form of a document or that says what someone said and they're not there. So from the Melendez-Diaz case and the Crawford case, you learn that it's not just verbal statements, but it's also written statements, written utterances. So that's when we took a break for the book to learn a little bit more about hearsay in those two cases. Then we moved back to the textbook to section 3, where we talked about cross-examination. Now this is very important because this is that time where now the opposing parties are now exercising that Sixth Amendment right to confront and cross-examine witnesses. Now, if you're a witness on the stand, you are now the opposing witness, and the opposing attorney is now questioning you after you've been questioned by on direct examination by the attorney that called you. Now you are a hostile witness, because you're on the opposing side. So the opposing attorney is now allowed to ask you leading questions, and they can now ask you questions that suggest the answer in the question itself. So let me see. The main objectives for cross-examination, because you're now getting questioned by the opposing parties, that it means they're trying to discredit you. They're trying to either discredit your perception. So did you see what you thought you saw? Or they're trying to discredit whether you know what you're talking about. And sometimes they're even discrediting your ability to tell the truth. Like, it's this person lying. They're trying to establish biases and all that stuff. So there are differing reasons for or differing cross-examination objectives. So it just depends on a case-by-case basis, and it depends on what you mean to the prosecution's case as well as the defense's case. So while you're there is going to determine how you're going to get questioned and what the objective is going to be on direct and cross-examination. But specifically, we're talking about cross-examination now. So that was chapter 11. Chapter 12, recognizing cross-examination objectives. Sometimes, now remember, as a witness, it's not your job to be the attorney. You have to let the attorneys argue, and you have to let the attorneys prepare and strategize for trial. Your job is to be an empty vessel that comes in and says, this is what happened. You got to let the attorneys be attorneys. It's not your job to try to forecast what's going to be asked and why, so that you can now prepare an answer, because that sounds a lot like lying. Either you're coming in there, you're saying what happened and telling the truth, or you're coming in there and you're prepared to answer questions, whether it's the truth or not. You're prepared to answer your questions in a manner just so that it'll hurt the other side, whether it's the truth or not. That's not why you're being asked to come in. So whether there's going to be some things that you say, let's say if you're a cop, there are two types of evidence, right? There's inculpatory evidence. Culpatory means guilty. So if it's inculpatory evidence, it's evidence that tends to prove a person is in guilt or guilty. And then there's also exculpatory evidence, EX. which is out. So if there's exculpatory evidence, this is evidence that tends to prove that a person is out of guilt or not guilty. So sometimes, as a law enforcement officer, you may be asked to testify, but some of the testimony you give, if you're telling the full truth, may be kind of exculpatory. Guess what? If it's the truth, you gotta say it. You're not there to lie or be biased. Now, there's nothing wrong whatsoever with wanting one side or the other to win the trial, but you can't show that bias in your testimony. You gotta tell the truth, whether it hurts the case or not. Keep it real. Either you saw the man do it or you didn't. If you can say, well, I'm not sure, there was a tree in the way. I couldn't, the car was moving so fast, but I definitely heard a shot. So sometimes that may not help the case of the attorney that brought you there, but you're there to tell the truth. If the attorney had questioned you enough, they would have known that maybe you weren't going to be as helpful as they thought, and they wouldn't have called you. So they brought you there for a reason, and so they should know. And they know you're going to be subject to cross-examination, so they should prepare you for that, and they should be prepared for that. And they should make strategic decisions based upon how strong or how weak you are and how much you're going to help the case. So that's kind of the attorney's job to forecast that stuff, not your job. So if you're coming in as a witness to testify, you're not there to be an attorney. You're not there to be argumentative. You're there to just answer questions when asked. You're a vessel for the truth. You're trying to help the trier of fact, the jury, and the court figure out what happened. So tell us what happened. Don't skew it. Just keep it. Tell us what happened. Like I said, even in telling them what happened and being truthful, is still nothing wrong with maybe rooting for one side or the other, but you just can't give the advantage, and you can't lie and push the narrative you want in your testimony unless it's true. So you can't tell it's not. So you may get a question, is it wrong to want one side or the other to win in a case? No, it's nothing wrong with that, but it is wrong when you now skew or change your testimony to kind of direct and make sure that happens. That is lying. So then what else do we talk about? That's section 3. Then we talk about tips for testifying on cross-examination. Pretty much just know what you're talking about. And always know what prior, and make sure you go over any prior narratives or statements you wrote, so that you won't get caught up or impeached saying something different than what you've already wrote in the past. That's the big thing. So that was chapter 13. It pretty much ended, and section 3 was the last section in the book. So we put the book down. Then we jumped to scientific and admitting scientific evidence. We talked about Rule 702 of the Rules of Evidence, and a case, Daubert v. Merrill Dow Pharmaceuticals. Pretty much what happened in that case is there used to be an old standard or an old precedent from the Fry case out of 1923, I believe. And that case said, hey, if the scientific community does not support and not adopt what you're saying or what you're testifying to, is not allowed. So what that did was it essentially gave scientists and the guys with white lab coats, it gave them power in the court system. So if someone was coming to testify and there wasn't some scientific journal or some scientist or the scientific community didn't know about what they were testifying to, it didn't get in. So that meant certain things. So you can be an expert and asked to give expert testimony about just about anything in court. It's not just about that medical lab coat stuff, or I'm a doctor, I'm a ballistics expert. It can be about other stuff. It can be about you may be a hairdresser. And I always use this example because being a hairdresser or a barber is nothing that's thought as being scientific in the court of law. But let's say we're trying to identify a body, or we're trying to figure out what kind of weave is in this dead body's hair, because we're trying to identify this corpse, and you're there to say, well, it was this type of it's a weave, and it's Yaki 32. It's a special type of hair. Only certain places sell it in Greensboro. So are you necessarily a scientist, and is what you're testifying to supported or by the scientific community? Absolutely not. But is it relevant? Yes, it is. do you have a specific knowledge level, and do you know what you're talking about because of your experience? Yes, you do. So in the Fry case, you wouldn't have been able to testify because the scientific community doesn't support or doesn't what you're saying. In other words, you're not a scientist, so you can't come in and be an expert in court. But what happened, Rule 702 of the Federal Rules of Evidence and the support of the Dalbert v. Merrill Dow Pharmaceuticals, the holding in that case and the ruling from Rule 702 essentially said, if it's, in other words, if it's relevant and the person that's testifying has a knowledge base, then it is allowed in court, and the judge is the gatekeeper to determine whether or not it's relevant in court. So it established two things. So it must be a knowledge base. So you must establish this person as an expert that knows what they're talking about this specific thing that they're there for. And then it must be relevant, and then it also the judge decides whether or not it's relevant. So before, in the Fry case, it was almost everything. If it wasn't something dealing with something specifically scientific, something we generally classify as being scientific, then it wasn't coming in. So essentially, that means that the scientific community had a little bit of control of what happened in court from day to day, as opposed to relevant testimony having everything to do with what went on in court. So the Dalbert case kind of opened up what is allowed to be testified to in regards to an expert coming in to testify. So it opened up the gates of what could come in. Now, like I said, I say open up the gates. That doesn't mean any and everything can come into court, because it still has to be relevant to the case. And you still have a judge just sitting there to determine whether or not this is junk science and whether or not it's misleading. So there's still safeguards to keep any and everything from coming to court. So that's what we talked about. And that's pretty much all we learned over the whole semester. Went through the whole book, talked about a couple things outside the book that I wanted to kind of get into your head. And that was it. Of course, we had a group thing that didn't kind of work out. So, because of the virus and things like that. But that's our cumulative course review. So the exam is 40 question exam. So it's 40 questions. And what I will tell you, I'll go ahead and let you know this, because I'm Captain Save a Student. You guys have already had 3 quizzes, right? And each one of those 3 quizzes had 10 questions on it. I'll let you know now that the first 30 questions of this exam are questions from the quizzes. So you're going to get a repeat of the first 3 quizzes, quiz for section 1, 2, and 3, and pretty much the last 10 questions are going to be new questions that deal with new things we talked about. So we're going to talk about, you're going to get questions on the hearsay rule and some of this new stuff that we talked about, the hearsay rule and scientific evidence, and even the process of tendering a scientific testimony, like the fact that a person doesn't just walk in and say, yes, I'm an expert and this is what happened. No, you have to tender them as an expert. So before you tender them, they have to talk about why they are credible. What is their educational background? In other words, what gives them the basis of knowledge to be here to testify about this specific thing, and why are they relevant? And then once they establish that they're relevant and they know what they're talking about, then you tender them as an expert, and then they're allowed to testify about that specific thing that they're an expert in. So it's not just walking in the court saying, yep, I'm an expert, and sitting down and talking. As a matter of fact, if a person is going to be brought in as an expert, the opposing counsel can actually do what we call a voir dire. Now, the 2 voir dires is the voir dire where there's questioning of potential jurors. That's at the beginning of a trial. There's another in-trial voir dire where if a person is going to be tendered as an expert, the opposing party counsel gets to question them outside the presence of the jury to determine, for the judge to determine as a matter of law and a matter of evidence, that the rules of evidence, whether or not this person should be an expert. So they kind of get to challenge them on whether or not what they're going to testify to is relevant, for one, and then also whether they have the knowledge base to be an expert to give this testimony. So that's what we call a witness voir dire. And then the judge can decide whether or not to go forward and let this person testify or not. But if they are going to testify, they may be subject to that. So that's why coming in and being prepared and being prepared to say why you know what you're talking about is important. So you must be fully tendered. So the foundation, we call it laying the foundation. The foundation must first be laid for why what you're testifying is one, relevant, and why you're an expert at it. What is your knowledge base? So they have to kind of bolster your credibility first, and then tender you as an expert. And then once they tender you as an expert, like I said, the opposing party can still say, I don't think so. I want to voir dire this person. Please take the jury out. So that can happen. So the foundation must be laid first, then the person is tendered as an expert, and then they can testify. So they don't just walk in and say, hey, I'm smart, I want to testify about this. Doesn't work that way. So talk about a little bit of that in the questioning. So like I said, first 10 questions, the last 10 questions are new. The first 30 questions are old. I'm not going to tell you what order they're in, but you would have seen these questions before. So that is the exam review as well. It's, like I said, it's 40 questions. There's going to be there is one extra credit question that's worth 5 additional points that can apply throughout the semester for whatever if you didn't have the textbook, which is worth 5 points, you can make that up by doing perfectly on the final and getting that extra credit question right. That gives you 45 points instead of 40. So if you did something wrong or you missed out on an opportunity early in the semester, you can now get that opportunity back by getting that 5 points, and that 5 points can be spread over anything over the whole semester. So we're just tallying points in this class. So you're graded out of 100 points, and if you look in your syllabus and you see how everything is graded, it's going to equal out to being 100. So whatever you get out of 100, that's how you're going to be graded on the plus minus grading scale provided by the university and in the syllabus. So, but that is it. Of course, if you have any questions, please email me. And you guys know my email address, or you can text me. I'll leave you guys my business mobile line as well. So it was a pleasure to teach you guys this semester. What I will say is these are trying times. You're not in this by yourself, and you're not the only one having a hard time. I'm out here looking crazy. I ain't got no haircut. I'm looking crazy. I'm here in the white V-neck teaching y'all. In our guest room / office where I hang my shoes and stuff. You see in the background. So this is really harsh, and it's a different way to have to now give instruction. But I've had to adjust as well. So if I can do it, you guys can do it. And I'm not just talking about for this class, but I'm talking about in general. I know this was abrupt and you were asked to do things. You were asked to get out of your comfort zone. But guess what? Suck it up. You have a day or two to kind of, unravel and you can have a breakdown, but you got to wake up and you got to finish this semester out. So you can do it. Of course, some of the requirements that we had, of course, I had to change the group project. We had to do discussion board. But nothing was adjusted without you guys knowing. So don't use this as an excuse to not do your work. Okay, do your work. You're a college student. Remember the responsibility. Remember, as a college student, you're sitting in someone's seat. There's someone that wants to be where you are, that doesn't have the means, or they didn't do something right, so they're not where you are. So remember how blessed you are, even in this COVID-19 crisis. You're still here, you're still alive, and you still get to be a college student. So just remember that. Make the best of this bad situation and just be a good student. So on that note, Aggie Pride and Boyce loves you. Y'all be good.